Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. I apologize today. I have a rather bad upper respiratory infection, and as a result of that, my voice is a little bit impaired. I hope that it will not be unpleasant to listen to. So, this interesting case today is about a company that you've probably already heard of, Norton. Now, for those of you who've heard of Norton Utilities, Norton Antivirus, LifeLock, Symantec Software, you'll know the losing party in this litigation, but you may not know its new name. That new name is Gen Digital. The plaintiff that prevailed in this litigation was Columbia University. Columbia had two professors who developed and patented computer subroutines for the detection of malware. Norton infringed on those patents. That's what the jury found. Now, usually when folks are caught doing something like this, they will go into a licensing agreement and pay the inventors, and that way they don't have to get sued. Sometimes they even do that after they've been sued. But Norton here did not do that. They decided instead to contest the charge of patent infringement, and they hired the Quinn Emanuel law firm to represent them. That was over 10 years ago. There are two statutory provisions in the patent law that provide for additional relief in a patent case. Section 284 provides for enhanced damages. The court can, if it finds the proper facts, increase the jury's award by a factor of 3 or any smaller factor. Section 285 provides that the court can award lawyer fees too. Now, normally patent fights are slugged out between corporate rivals, and as a result, there often isn't a need to award either enhanced damages or attorney's fees. And that's especially true with regard to litigation misconduct because most lawyers do not misbehave. But where someone does misbehave during litigation, both of those statutory sections can come into play. And that's what happened here. In this case, out of the Eastern District of Virginia, Norton, through its law firms, did some pretty skeevy things. Because of that, the plaintiff sought additional compensation. Normally, when enhanced damages are considered, it's the defendant as defendant that is guilty of the misconduct. But here, it's the defendant's lawyers. The court, in describing what happened, said, Norton engaged in substantial and egregious misconduct throughout the litigation. As you might guess, that's not good. And on the third page of this 42-page order, the court writes, Therefore, the court finds by a preponderance of the evidence and in its discretion that this case warrants both enhanced damages and an award of reasonable attorney's fees. Wow, what did those lawyers do? They violated rule number 1, don't honk off the judge. They made the judge mad, and as a result, they reaped the whirlwind for it. Now, before the case went to trial, the lawyers claimed to be representing both one of the former employees of Norton, Dr. Dassier, as well as Norton itself. But Dassier didn't need representation, and he'd told Norton his testimony would not help them. So they told him that the court found that they, Quinn, were representing him. That was untrue. The court had actually ordered them not to represent Dassier because of a conflict of interest. Dassier's interests were not aligned with Norton's interests. They had also told him that Norton wouldn't need anything from him. This was technically true, but it wasn't factually true. They never told him that he'd been subpoenaed by Columbia University and that he'd need to make arrangements to fly back from Saudi Arabia where he worked and appear for trial on behalf of Columbia. The court was not amused and did not mince words when she described what happened. Norton's conduct rendered Dr. Dassier unavailable to Columbia. When deciding how to possibly mitigate the prejudice suffered by Columbia due to Norton's misconduct, the court identified the exceptionality of the case, noting that it has never before had the feeling that a company hid a witness and was untruthful to the witness about what the court had said about it. Despite being in trial litigation a long time, I've never seen it, never. They also relitigated issues that had already been decided. Now, when a court makes a legal ruling, that ruling stands unless the court reconsiders it, and you can file a motion to reconsider, and Norton did that. That motion was denied, but in spite of that, they filed Daubert motions and responded to other Daubert motions, in each instance attacking the legal ruling that the court had made regarding the term application community. They refused to accept the court's definition. They wanted their definition. That's not all. They mischaracterized the record. Norton filed a motion to exclude certain licenses from trial. They claimed Columbia had not produced them, but they failed to point out to the court that they had agreed to a lesser production, and they got everything they were entitled to. So here's what the court said about that. The court ruled that Norton could not now seek to exclude information based on the defunct broader request for information regarding Georgia-Pacific factors after Norton agreed to narrow its request as to documents relating to license. In sum, Norton advanced a frivolous and misleading argument. Two words you really don't want used to describe your lawyer's conduct are frivolous and misleading. In addition to that, they relied on data that the court had said was patently irrelevant. Their pretrial conduct was pretty bad. Once they got to trial, it didn't get any better. They cross-examined witnesses using incorrect or misleading predicates. In other words, they put words into witnesses' mouths, or they provided data in cross-examining questions that were misleading. They asked questions that witnesses could not possibly know the answer to, and on premises that were not before the court. And here's what the court said about that. Third, the court pointed out several instances where Norton's cross-examinations crossed the line into improper or misleading questioning. For example, with the jury excused, the court reprimanded Norton's counsel for this precise type of conduct. Warning, I do appreciate strong advocacy. I really do. But I think you have heard me say I'm a little concerned about how you have presented some of your questions to these witnesses. Cross-examination is fair, but it's not fair if you've misrepresented what a witness has said. The court then recounted 4 more times when she had warned Norton's lawyers they were crossing the lines, and then several more times when she had given them warnings, and this culminated in the court saying, after Norton's improper cross-examination of Dr. Cole employing the same conduct against which the court had warned, the court stated again outside the jury's presence, don't do it again. Do you hear me? Not by accident, not respectfully, not anyway. Do not do it again. I will instruct the jury that you're doing that too many times, and they should take it into account. I'm telling you that. I have never seen that kind of a rebuke given to a lawyer before. It's a good thing the jury wasn't in there. Norton's lawyers tried to introduce improper figures and used improper and misleading demonstrative exhibits. Demonstrative exhibits are things like you would hold up that would have, something on them to show, for example, a diagram or maybe a flow chart, since we're talking about software, maybe a flow chart for how the algorithm worked, that sort of thing. Those are the kind of demonstrative exhibits that we're talking about. The court then reviewed the factors that go into an enhanced damages determination, and I won't go through all of them, but let's take a look at what the court said about the third factor. The third factor looks to Norton's behavior as a party to the litigation. Courts will look to see if the party engaged in litigation misconduct, such as bringing vexatious or unjustified suits, discovery abuses, failure to obey orders of the court, or acts that unnecessarily prolong litigation. If this conduct rises to the level of malicious, enhanced damages are appropriate. Now, here, Norton's abhorrent conduct in this matter strongly indicates that it acted with sufficiently culpable conduct to support an enhancement. Again, abhorrent is not a word you want used to describe your lawyer's behavior. Having found this abhorrent behavior, gamesmanship, and a general playing fast and loose with the rules of professional conduct, the court determined, after weighing the factors, to multiply the jury's verdict by 2.6. Well, the jury's original verdict was $185,112,727 in damages. But after multiplying, it was $481,293,090. Now, Norton is going to have to pay this, although it will likely appeal the verdict and the enhancement. The real question is, will the law firm have to pay anything? Given how strongly the law firm's conduct weighed on the issue of enhancement, Norton might well have a legal malpractice claim against the firm. So we'll just have to see how this comes out at the end of the day. Well, that's what I have for you today. Hopefully you found this interesting, entertaining, and it's always fun to sort of poke fun at lawyers. If you have the opportunity today, please take a moment to be kind to someone, do something nice for them. And then, when you're done, be kind, be thoughtful, and be back here tomorrow. We'll talk about something else. Thanks for watching. Have a great day, guys. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.